Hello everybody and welcome back to the Law of Contracts. In this lesson we're going to talk about the next major circumstance in which we can bring a contract to an end, and this is by reference to the doctrine of mistake. Now, in previous lessons, we spent quite a lot of time examining the nature and the extent to which misrepresentation could be representative of a vitiating factor within contract law. We noted that there are various different kinds of misrepresentation, ranging from the idea of innocent misrepresentation on the one hand, all the way to fraudulent misrepresentation on the other. This lesson is, like I said, going to speak about the doctrine of mistake within the law of contracts, another major doctrine, another major element of doctrine that we need to explore in more detail. So, the doctrine of mistake does exactly what it says. It provides a stipulation that where a contract is essentially done on the basis of a mistake, that contract can be made void, or at least voidable, by the parties to the contract. We can divide the doctrine of mistake into three major types of mistake that it can exist in contract law. The first is this idea of common mistake. Okay, this is the first type of mistake that can exist. The second is mutual mistake. And then the third is unilateral mistake. And you can probably come to a conclusion as to what these things mean just by looking at how they are written and what they are called, but we will get to this in more detail throughout this lesson. So, common mistake exists where there will be an agreement, but both parties are mistaken in relation to the fundamental part of the contract itself. This is often in relation to some fundamental part of the subject matter of the contract itself. So, they are mistaken as to what the fundamental condition of a contract may be. Remember that there are various different ways in which we can delineate terms of a contract, and we've done this already. And we noted that conditions of a contract strike to the heart of the contractual arrangement, such that if a condition is to be misrepresented or to be mistaken, then you are mistaken as to what the very nature of the existence of the agreement even is. An example of this taking place can be seen in the 1856 case of Courtier and Hasty. In this case, the first kind of common mistake is illustrated in this particular case, where there is a mistake as to the existence of the subject matter of the contract itself. This is known as res extinctia. Essentially, it involved the sale of Indian corn, which was in transit as cargo. During the transport of this cargo, however, the corn itself became unfit for sale and use, and so as a result of this, midway through the journey, the captain decided and made the decision to sell the cargo off to a third party. All while this was happening, while the sale was going off in a different period, in a different area, okay, the parties were contracted for the sale of the cargo under the assumption that it still existed, that it was still under the control of the captain of the ship. While some may believe foul play on the part of the captain, it was actually common and customary practice for a captain to go about selling cargo in this fashion if it was deemed to have been unfit for further transport. So it was actually quite a common feature, basically, essentially saying that if rather than having the cargo be unfit and arrive at its destination unfit and unable to be actually utilized, sell it as quickly as possible. If it's deemed to be unfit later on in the journey, in the voyage, then sell it now, essentially. But then when it comes to the contractual ideas relating to mistake, it argues here that when the claimant made the argument that the defendant should pay for the corn owing to the fact that they had taken on the liability in its transport, the courts held that the contract itself was rendered void. And it was rendered void, of course, because the contract did not exist owing to the fact that the subject matter did not exist. If the subject matter of the contract did not exist, then the contract itself would not exist. If I contracted with my friend to purchase an alien spaceship, okay, I couldn't then sue that individual if I don't get my alien spaceship. I've made a contract on the basis of a subject matter that did not exist. There does not exist an alien spaceship, at least if you don't believe the conspiracy theorists, at least. And so as a result of that, there's no subject matter. This is known as a res extinctia. In this instance, we have here that, like I said, there is a contract of a sale of corn, but that went off and disappeared. Okay. A similar thing can take place if you've got the transport of property that's going in cargo. You make a contract for the purchase of that cargo, but at some point along the journey, prior to your making of this contract, the cargo falls overboard, or it gets destroyed in a fire, or something like that. But you don't know that it has happened, so you're basically contracting for the sale of an object that no longer exists or is no longer available to you. As such, as a result of which you have the idea of common mistake. In the case of Cooper and Phibbs from 1867, we can illustrate the second type of common mistake that can exist. This time we're not talking about the very existence of the subject matter in terms of common mistake, but rather we're talking about common mistake between the parties as to who the true owner of the subject matter is. This is known as a res sua common mistake. So, in this case specifically, there was a mistake relating to the renting of a fishery. The claimant had rented the fishery believing that it was owned by his cousins. In reality, this wasn't true. It was actually the owner of the property. He was actually the owner of the property, should I say. So he was renting it believing he didn't own the thing that he owned. He was renting his own property, essentially. And then, as such, he sought to get a contract rendered void on the basis that there was a common mistake here. We're not talking about a mistake as to whether or not the subject matter existed, but the true owner of the subject matter. He was already the owner of the subject matter, so there was a mistake as to who owned the subject matter in the contract, so it should be rendered void. And in reality, this is what happened. It got rendered void on the basis that there was this common mistake. Because you can't, of course, make a contract on the basis of there being a failure to know the true owner of a subject matter. If this happens and you are wrong about the true owner of the subject matter, then you can render a contract void on the basis of common mistake.